Welcome to J is for Justice podcast. If live breaking news and following true crime is your thing, then please consider subscribing to my channel. And if you like what you see in my videos, please consider giving them a thumbs up. Podcast. Sorry, I screwed that up. Welcome in, everybody. I don't know if you guys heard that intro or not. Welcome in. Welcome in. Let me know if you can hear me okay. We are live from Studio J. I just got back from the pool, so I'm a little discombobulated. Bear with me. We've got Karchi and Ange B and Kels all here moderating today. We've got some clickers, Helen, Leslie, and Billy. Happy Friday, Gypsy Witch Queen. Note to self. Happy Friday, Betty. Coming in hot, just like the fajita. Oh, you did hear it. Okay, because I had my speakers on, so I thought maybe I screwed it up. Happy Friday, Megan and Steph and Melissa B, Aunt Key, Pew Deb, Naomi, Lucid, Wendy M, Siobhan. I know some people hate when you start a live and say hi to everybody, but I just feel it's needed. Welcome in. So we were going to go over some Brian Koberger documents, but F all that because we've got breaking news. Share it out. Chad Doerman had a change of heart and suddenly has pled guilty to the murder of his 3 sons. You heard me. He has pled guilty. Thank God. He's going to be sentenced as well, I think, in this hearing. We're going to watch him plea and be sentenced, I believe. Yes, it's good when we see these men who are clearly guilty accept the guilty plea. Happy birthday to your youngest, Gypsy. Happy birthday. Kelly Mack, welcome in. Kim Maple Syrup and My Kid's Keeper. Good afternoon. Justice for these little boys, if there is a such thing. Dispatch Crystal, I appreciate you acknowledging everyone. Thanks, Crystal. What's up, Tim Sparks? My Seaboing friend. My former Michigander. Let's see, 20 minutes. Oh, you were 20 minutes in. Jill, welcome in. All right, we're over 100. I guess we can start. But please do share this out. This is big news in the Chad Doerman case. He gunned down his 3 young sons on June 15th, 2023. And then there was a lot of legal shit going on. It was, pled guilty by reason of insanity and all this stuff. And now we have this surprise plea hearing. Yes, come on in. TLC. Yes. Sweet Crazy, good to see you. Proud Fur Mom, good to see you as well. Siobhan just gifted a membership and Cheryl received it. Welcome, Cheryl.
Jennifer loves horses.
All right, you guys ready? Leslie Rogers, what's up? You guys, I just ask that you be patient with me this weekend. I know we have a lot of updates to cover. I know I want to go over the Katie Proudfoot restraining order and all of that good stuff. I have my granddaughter until tomorrow, so we are on hold until then, but I plan on being live Sunday. I just don't know when yet, but we will get everything out there. I want to, react to that because there's a lot to talk about. So in the meantime, if you guys can just be patient with me. Family first, right? But this is Chad Doerman appearing in court today, roughly about an hour ago. Here we go. Thank you for being here. And if you could hit that thumbs up, I'd appreciate it. Thanks, guys. Yeah, we'll talk about that tropical storm September. Not sure where it's going to hit yet. but we've got some work to do with we have a little bit of a leaky roof we got to take care of before this. Angie B gifted another membership, and TLC, welcome to the Clickers. Sherry, your shirt looks fabulous on you.
All right. Court is reconvened. Please be seated.
Good afternoon. We are here on State of Ohio versus Chad Doerman, case number 2023 CR 407. Mr. Doerman is present with counsel, Mr. Myers, and Mr. Haynes. The state's president, represented by and through Mr. Colby, the county prosecutor, Laura Barron Allen, first assistants, Catherine Terpstra, and Mr. Clay Tharp. And we're here this afternoon because I have been advised that a plea agreement has been reached in this matter. And there's a couple of things that we need to address before going into that lengthy process. First of all, there's obviously media here. They're live streaming this. There will be two of the victims are going to appear this afternoon, and at least initially statements are going to be read on their behalf, and they may address the court as well. They have requested, and pursuant to Ohio Superintendent's Rule 12, they're not to be imaged in any fashion by the media. There are not to be any still photographs taken of them, period. There's not to be any videotaping when they appear. There's to be no image of them, period. Cannot be live streamed. It's my understanding that Ms. Barron Allen, they read the statements and they can hear the statements, but do not, under any circumstances, photograph them or videotape them when they come into the courtroom, when they are standing at the podium, and when they leave the courtroom. So I hope all of you understand that. I'm sure you do. You're professionals, so make sure you follow that admonition. Mr. Myers, anyone from Mr. Doerman's family going to speak that would not want to be imaged as well?
No.
Okay.
Thank you for asking.
All right. And then there's a couple of other things that we're going to put on the record initially just to clarify some waivers. As will become more apparent throughout this process and the plea that is going to be entered, there are two things that could be applicable but really will not be applicable. Two of the charges that Mr. Doerman will be entering pleas to this afternoon are felonious assault. They are second-degree felony offenses. In Ohio, under the Reagan-Tokes Act, there are certain notices that I have to provide to anyone who is sentenced under the Reagan-Tokes Act. There are notices as to when they may be released. And as I've indicated, as we go through this process, those notices are absolutely inapplicable here. And for me to go through that process, number one, would be simply a vain act because they will not be applicable. So as to the Reagan-Tokes piece of this, is that your understanding, Mr. Colby, that can be waived?
It's my understanding, Judge, yes.
And Mr. Myers, on behalf of Mr. Doerman, it's your understanding that he's willing to waive those notices?
That is correct.
We waive those. And just for the record, I mean, there will be times when I ask both you and Mr. Haynes to comment, but primarily I'll address questions to Mr. Colby and to you, and that's no slight to anyone else. That's just easier. All right.
I interrupt. Something just occurred to me that the defense would like to acknowledge and agree that before we went on record for this hearing at, I believe, 1:15 this afternoon, the state caused to be filed an entry signed by this court.
I'm getting to that.
Okay.
Okay.
Want to acknowledge jurisdiction?
No, that's down my checklist.
All right.
The second item is Mr. Doerman is going to be entering a plea of guilty to 3 counts of aggravated murder. And there were aggravating circumstances returned on all of those, which obviously made him eligible for the death penalty. The state, as part of the plea agreement, which will be discussed shortly, has dismissed those 9, all the aggravated circumstances in each of the 9 aggravated murder counts. So those aggravated circumstances have been dismissed. That entry has been filed with the clerk and is a record. So consequently, this is no longer considered a capital case. And Mr. Tacalvi, that's your understanding, correct?
Correct, Judge.
Okay. And Mr. Myers, that's your understanding as well?
Yes.
And the reason we put that on the record is because in all other proceedings, when this was a capital case, there was a court reporter physically present taking notes, which is required, or transcribing the events, which is required. And because this is no longer a capital case, the court reporter is not present. Obviously, it's being recorded. All these microphones pick up the sound, but that's the reason why we have made that part of the record. And then the other piece of this is, given the nature of the offenses that Mr. Doerman will be entering a plea to, normally he would be required to register as a violent offender. Again, as we'll work through this, the violent offender registration is inapplicable. And rather than read something that is essentially a vain act, similar to Reagan-Tokes, to read that's a vain act because it doesn't apply, both the state and the defense are waiving any necessity for me reviewing the violent offender registration requirements. And Mr. Colby, correct?
That is correct, Judge.
And Mr. Myers, correct?
Correct.
All right, thank you. So we're going to start this plea process. It's a lengthy process, and it's important to know that I don't want any people leaving in and out of the courtroom. You're here, you're here. If you leave, I prefer you don't come back because it's disruptive, and I prefer not to have disruptions for obvious reasons. It's a very serious process, and we need to get through this effectively and efficiently. This is not a race, but it's much better if there's just no in and out of the courtroom, except for the fact that the victims will be brought in at some point in time. They're not here now. And so I'll go ahead and then get started with this. And again, I've acknowledged counsel and the parties, and we have, and I also know that the victims have been notified of this hearing, and they are present. I've already discussed the requirements of the media regarding photographing the victims when they are here. And the 2 victims that will be here, at least at this point, will be Laura Doerman and Alexis Skeen, Mr. Doerman's former wife and stepdaughter. And those are the only 2 that will be here, and obviously that prohibition of recording in any fashion will apply to them. And initially, Mr. DeCalvi, if you would if you would state on the record the nature of the plea agreement that has been entered into in this matter.
Yes, thank you, Judge. It is an agreement, Your Honor, between the state and the defense that the defendant will enter a guilty plea to count 1, aggravated murder. That involves the killing of Clayton. The defendant will enter a guilty plea to count 2, aggravated murder. That involves the killing of Hunter. Guilty plea to count 3, aggravated murder, involving the killing of Chase. Will also enter guilty pleas to counts 18, felonious assault. That involves the actions he took against Alexis Skeen. And he will enter a guilty plea to count 20, felonious assault, for the actions he took against Laura Doerman. The additional recommendation, Your Honor, is that count 1 will be life without parole, consecutive to count 2, which will be life without parole, consecutive to count 3, which will be life without parole, consecutive to count 18, which will be 8 to 12, consecutive to count 20, which is 8 to 12 years in prison.
Well, and just to correct, the Reagan-Tokes piece of this is complex, and that the actual sentence for count 18 and count 19 would be an 8-year minimum sentence on each, served consecutive, or 8 rather, an 8-year minimum sentence served consecutively with one another for a 16-year minimum prison term. And then under Reagan-Tokes, I'm required to take 50% of the most serious felony offense, which would be 18 or 20, doesn't matter, which is 4, add that to the minimum. So the actual sentence that, if it was just Reagan-Tokes only, would have been 16 to 20 years, and obviously served consecutively with counts 1, 2, and 3. Correct? And Mr. Myers, that's your understanding as well?
Yes, that's our understanding and our total agreement that I think the court has just now adequately, along with the state's counsel, summarized Reagan-Tokes as it really doesn't apply here.
Yeah, and I'll go through that through the plea because I have to, but nevertheless, we're all on board with that. And I know, Mr. Colby, you have discussed this fully with the victims in this case, and they're on board with this. They're in agreement with the plea agreement, with the agreed prison sentence, and they're also willing to go forward today with sentencing without the necessity of presenting a victim impact statement, which would normally be presented through a pre-sentence report, and we'll address that momentarily as well. But that's correct?
That's all I have, Judge, yes.
And this is obviously the best plea bargain that has been or will be presented to Mr. Doerman.
Correct.
All right. And that's your understanding as well, Mr. Myers?
It is, Your Honor.
All right. And as I've indicated, it is also the dismissal of the aggravating circumstances has been filed, so those are, as they say, off the table, and Mr. Doerman is not eligible for the death penalty. We discussed the aspect of the no longer the necessity of having a court reporter physically present in this process. And I know, Mr. Myers, we also discussed that as a result of the plea agreement, you will be, on behalf of Mr. Doerman, withdrawing his written plea of not guilty by reason of insanity, and you'll also be withdrawing the motion that was filed to be heard Monday regarding the serious mental illness factor under 29025. Is that correct?
It is correct on both issues, Judge.
Okay, and I'm sure you've fully discussed that with Mr. Doerman, and he fully understands why that is being done.
I believe he does.
All right,
and
thank you.
We have, in fact, discussed it.
I'm sorry?
And we have, in fact, discussed it with him.
Okay, I know. And I'm sure that you and Mr. Haynes have fully discussed the agreed prison sentence as well as the agreed prison sentence with Mr. Doerman, and he is in full agreement with proceeding today as outlined by the state, and of course your concurrence in the plea agreement and the agreed sentence.
That is correct, with the sentence to be imposed today.
All right, and we'll go through that as well. And Mr. Doerman, prior to this agreement being made, did Mr. Myers and Mr. Haynes fully review with you all the evidence that had been presented to you or to them, discussed with you all the possible defenses you may have to these charges, reviewed with you, explained the trial process for a death penalty case and the sentencing aspects of that, and did they answer all your questions regarding those matters sufficiently for you?
Yes, Your Honor.
Okay. And your voice is strong enough, just keep it up. That's going to, we're obviously making recordings, so just make sure you keep your voice up. And before I ask you any questions going forward, I need to make sure that you have not taken anything, even prescription medication, that would interfere with your ability to understand and comprehend what you are doing this afternoon. Is that correct?
Yes, Your Honor.
And you're clear-minded this afternoon?
Yes, Your
All
Honor.
right. And Mr. Myers, I know the two of you have met with him and discussed this matter with him. Obviously, you've had a number of contacts with him, obviously, but are you satisfied that with your discussions with him today and this afternoon that there's every indication that he's fully aware of what he's doing, not impaired in any way as far as being able to understand what he's doing and comprehend the process that we're about to engage?
Yes, Your Honor, that is my understanding, and I'm sure Mr. Haynes joins in that judgment as well.
All right, Mr. Haynes
I
is,
do, Judge.
Mr. Haynes is nodding yes. And Mr. Doerman, up to this point in time, have you been able to understand everything that has been discussed, both what I have stated, what the prosecutor stated, what your counsel has stated up to this point in time?
Yes, Your Honor.
Okay. And if at any time during this process, Mr. Doerman, you want to talk with your attorneys about anything, just let me know, and we'll make sure that you're able to do that privately and confidentially. And if you feel you need to take a break at any time during this process, again, let me know, and we can accommodate that as well. And candidly, if something comes up, counsel need a break, we can take that break as well. Like I said, this is not a race. We just need to pursue this appropriately. And Mr. Doerman, if at any time during the process I say something to you that you do not understand, or I ask you a question that you do not understand, please do not hesitate to ask me to state it again, rephrase it. And if you still don't understand, you can talk to your counsel about it. You understand that. I know you graduated from Amelia High School. You attended Claremont College for a short period of time. And I'm sure that you fully understand and comprehend the English language. Is that correct? Fair to say? All right. And it's very important, Mr. Doerman, for you to fully understand that the decisions you're making and the consequences of those decisions. And I must rely on your responses to my questions to determine that you do understand what you're doing here today, that you're entering your pleas knowingly, intelligently, and voluntarily, and that if at any time there is a question, you need to let me know so I can clarify that. You understand that?
Yes, Your Honor.
And you should not interpret anything that I say here today as any type of an indication that I think you should or should not plead guilty. I'm not trying to talk you into or out of anything today. The decision of whether to plead guilty or not to plead guilty is yours alone. You understand that?
Yes.
All right. I'm going to review the indictment with you initially prior to entering the plea agreement process so that there's a clear understanding of what you were originally facing. There's a total of 21 separate charges in the indictment. Counts 1 through 9 each allege aggravated murder as an unclassified felony, and each also allege 3 aggravating circumstances. There's 1 firearm specification as to the first 9 counts. There's also a firearm forfeiture specification as well. And if you have been convicted on any one or more of counts 1 through 9 and any one or more of the aggravated circumstances in each of these counts, you would possibly face the death penalty. You understand that?
Yes, Your Honor.
The counts 10 through 17 each allege kidnapping, and each also allege one firearm specification and 1 firearm forfeiture specification. You understand that? Counts 18 through 21 allege felonious assault, and each also allege 1 firearm specification and 1 firearm forfeiture specification as well. You understand that?
Yes, Your Honor.
All right. I'll now explain the charges that are part of the plea agreement. And this plea agreement is, as the prosecutor stated, you'll be entering a plea of guilty to count 1, aggravated murder as an unclassified felony. Count 2, aggravated murder as an unclassified felony. Count 3, aggravated murder as an unclassified felony. Count 18, felonious assault, a felony of the 2nd degree. And count 20, felonious assault as a felony of the 2nd degree. In exchange for your pleas of guilty to counts 1, 2, 3, 18, and 20, the state will dismiss all the, and actually have dismissed all the aggravating circumstances that would have made you eligible for the death penalty as to counts 1 through 9. All firearm specifications that were applicable as to counts, all 21 counts, are being dismissed. You're going to agree to forfeit the firearm only, and then the state obviously then will be dismissing counts 4 through 9, the other aggravated murder counts, counts 10 through 17, the kidnapping charges, and counts 19 and 21, felonious assault charges. So with the dismissal of all the aggravating circumstances in counts 1 through 9, and in particular counts 1, 2, and 3, the counts you are entering your pleas to this afternoon have eliminated the potential for any death penalty. You understand that?
Yes, Your Honor.
In addition to pleading guilty to counts 1, 2, and 3, you and the state are recommending what I refer to as a jointly recommended agreed sentence as to these 3 counts, and I'll discuss the other 2 momentarily. In each of these 3 counts, you agree that the court will impose today a sentence of life in prison without the chance of parole for count 1, the same sentence in count 2, and the same sentence in count 3. And all of these sentences will be served consecutively with one another. That may sound somewhat unusual because life without parole is life without parole, but essentially they're being ordered to be served consecutively so that it is unmistakably clear that you will spend the rest of your life in prison with no chance for parole. So you understand those sentences and the consequences of those sentences.
Yes, sir.
Again, these will be served consecutively with one another. As to counts 18 and 20, they are second-degree felony offenses, and the jointly recommended agreed prison term as to each of these 2 counts is a minimum of 8 years on each count. Each minimum sentence will be served consecutively with one another, so I total those to arrive at a total minimum prison term of 16 years. Under the Reagan-Tokes Indefinite Sentencing Act, I'm required then to take 50% of only one of the most serious second-degree felony offenses, which would be 4 years. I then add that to the total minimum sentence to get to 20 years. So if this was a Reagan-Tokes sentencing only, the indefinite prison term you would serve is 16 to 20. Obviously, that 16 to 20 years it's going to be served consecutively as well, but it will be totally consumed, if you will, by the life without parole prison sentence, which is why we are eliminating any reference to potential early release date, because it's a vain act. There is no early release date for you. You understand that?
Yes, Your Honor.
So you understand the sentences that are going to be imposed at this point in time as to counts 1, 2, and 3, and as to 18 and 20. And just so that there's no misunderstandings, no misconception of anything that I'm talking about today, I will impose the sentence I've just discussed with you today. And we will proceed with that sentencing, obviously, at the appropriate point in time. And other than what I've just explained to you in terms of the number of charges that you're in your pleas to, the agreed prison sentence that you're entering your pleas to, the dismissal of all the aggravating circumstances in counts 1 through 9, the dismissal of all the firearm specifications in all counts, and the agreed sentence, obviously, that I've just gone over with you. Has anyone else made any type of a promise to you whatsoever to have you enter into this plea agreement and these agreed sentences this afternoon?
No.
Okay. I mean, I promise that I will impose the sentence that I just described to you, but other than that promise, no one else has promised anything else to you to have you enter your pleas of guilty this afternoon.
No.
And before we start the actual plea process and the sentencing process, it's important that I advise you of the nature of the various charges that you're pleading guilty to and the potential penalties that you are exposed to, irrespective of the agreed sentence. In count 1, it is alleged that on or about June 15, 2023, in Claremont County, Ohio, you purposely and with prior calculation and design caused the death of Clayton Doerman. This is in violation of 290301 and is an unclassified felony. Do you understand the nature of count 1?
Yes, Your Honor.
Count 2 alleges that on or about June 15, 2023, in Claremont County, Ohio, you purposely you did purposely and with prior calculation and design cause the death of Hunter Doerman in violation of 290301, and that is also an unclassified felony. You understand the nature of count 2.
Yes, Your Honor.
Count 3 is on or about June 15, 2023, again in Claremont County, Ohio. You did purposely and with prior calculation and design caused the death of, did I say Hunter was, Chase is count 3, Chase Doerman, an unclassified felony. You understand the nature of count 3. Count 18 alleges that on or about June 15, 2023, in Claremont County, Ohio, you knowingly caused or attempted to cause physical harm to Alexis Skeen by means of a deadly weapon or dangerous ordinance, a firearm, in violation of 290311A2, a felony of the second degree. You understand the nature of count 18.
Yes,
Count 20 alleges that on or about June 15, 2023, in Claremont County, Ohio, you knowingly caused or attempted to cause physical harm to Laura Doerman by means of a deadly weapon or dangerous ordinance, again a firearm, and that again is in violation of 290311A2. You understand the nature of count 20.
Yes, Your Honor.
The possible sentences for these various counts are as follows. As to counts 1, 2, and 3, those are all aggravated murder, all unclassified felonies. The possible sentences you could receive would be serving 20 years in prison before eligible for being for eligibility for parole, 25 years, a full 25 years in prison before eligibility for parole, 30 full years in prison before eligibility for parole, and then life in prison without the possibility of parole. You understand that?
Yes, Your
Yes. The maximum sentence I could impose, and that's count 1, would be life in prison without parole. You understand that?
Honor. Yes, Your Honor.
Count 2, life in prison without parole. You understand that?
Yes, Your Honor.
Count 3, life in prison without parole. You understand that?
Yes, Your Honor.
And I can and will order all of those 3 sentences to be served consecutively with one another. You understand that?
Yes, Your Honor.
As to counts 18 and 20, because they are felonies of the second degree, is a little more complicated to get to that, but you need to know what the penalties are and how we get there. Both of these, again, are felonies of the second degree. They carry a minimum of 7 or 8 years in prison, and there are 2 charges. They both carry that same minimum prison option. And what I have to do is select a minimum sentence for each of those counts, and because they're 2 separate victims, I can order them to be served consecutively with one another. And once I determine that they will be served consecutively with one another, which will happen today, I then, once I have selected the minimum sentence, I add those together. I then take 50% of one of the most serious second-degree felonies, add that to the minimum prison term total, and that's the indefinite prison sentence you could receive in this case. So as I'm going to impose an 8-year minimum sentence on each case, I'll total those together as they'll be served consecutively for a total of 16 minimum years in prison, a maximum prison term of 20 years. And again, those are going to be subsumed, if you will, by the indefinite or by the life in prison without the possibility of parole. But you understand how we get to that point.
Yes, Your Honor.
And as to each of the first-degree or as to each of counts 1, 2, and 3, I can impose a maximum fine of $25,000, totaling $75,000. I will not do that. As to counts 18 and 20, the maximum fine on each is $15,000. Cumulated would be $30,000. I'm not imposing a fine in that case. You understand that? And as a result of your pleading guilty this afternoon, Mr. Doerman, you're waiving following constitutional rights. You're waiving your right to a jury trial. You understand that?
Yes, Your Honor.
You're waiving your right of confrontation, which means if you had gone to any trial, your attorneys would have been able to question every witness under oath that came into court to testify against you. You understand that?
Yes, Your Honor.
You are waiving your right of compulsory process, which means if you had gone to any trial and you needed witnesses to help you defend yourself, I could have issued a subpoena. It's a court order. They would have been required to appear, even if they told you they did not want to be involved in your case. You understand that?
Yes, Your Honor.
You are waiving your right to require the state of Ohio to prove you guilty beyond a reasonable doubt as to all the essential elements of the charges I've just read to you, regardless of the trial you chose to pursue. You understand that?
Yes, Your Honor.
You are waiving your right against self-incrimination by pleading guilty. Obviously, that's the most incriminating thing you could say, but had you gone to any trial, no one, not even this court, could have ordered you to take a seat in the witness chair and testify against yourself for any reason. You understand that?
Yes, Your Honor.
By pleading guilty, you are surrendering the presumption of innocence that you have this afternoon. You understand that?
Yes, Your Honor.
By pleading guilty, you'll be making a full and complete admission of your guilt to each of the 5 charges I've just explained to you. You understand that?
Yes, Your Honor.
You'll also be admitting the truth of the facts that the prosecutor is going to read shortly that would enable me to find you guilty and proceed with sentencing. You understand that?
Yes, Your Honor.
And you are also accepting the jointly recommended agreed prison term, and you're waiving your right to appeal the sentence that can be imposed in this case. Is that correct?
Yes, Your Honor.
Throughout this process, you've been represented by Mr. Myers and Mr. Haynes. Have they fully explained all 21 charges to you, the aggravating circumstances that were involved with counts 1 through 9, the other specifications that were involved in all 21 counts? Have they done that?
Yes, Your Honor.
Have they explained in particular the nature of counts 1, 2, 3, 18, and 20, as well as the possible penalties associated with those 5 charges?
Yes, Your Honor.
Have they also discussed with you and shown you all the to them that would, in essence, support any finding of guilt in this case?
Yes, Your Honor.
Have they fully discussed with you any and all possible defenses that you may have had in this case?
Yes, Your Honor.
I'm sure they have also fully explained to you that by pleading guilty, you're withdrawing the not guilty by reason of insanity plea. Is that correct?
Yes, Your Honor.
And you agree with that?
Yes, Your Honor.
They're also withdrawing the motion for the hearing on the serious mental illness that was scheduled for Monday, and you agree with that as well.
Yes, Your Honor.
I'm sure that they have fully explained all the constitutional rights that you've just waived. Is that correct?
Yep.
And they have also fully explained the jointly recommended agreed prison sentence that will be imposed this afternoon. Is that also correct?
Yes, Your Honor.
By accepting by accepting the jointly recommended agreed prison sentence, you're waiving any option that you have, a right you may have had, for a pre-sentence report through the Adult Probation Department. You understand that?
Yes, Your Honor.
And you agree with that?
Yes, Your Honor.
And you're also waiving any right you may have had for an additional mental health evaluation through the Probation Department as part of the pre-sentence report, correct?
Yes, Your Honor.
Have they answered all your questions? Oh, wait.
One moment, if I may.
Sometimes there's a delay between the date made on plea and the date you get sentenced. And then the probation people themselves put a mental health evaluation. We don't need it because we put the sentence on it. That doesn't, those
Your Honor, I think we've clarified that.
Okay, all right. Have they answered all your questions thoroughly?
Yes, Your
No. And at this point in time, are you satisfied that Mr. Myers and Mr. Haynes have effectively represented you up to this point in time as to each and every aspect of the case that has transpired up to this point in time? That includes all the evaluations you've had for not competency, but for the NGRI plea, the SMI portion of this. You're satisfied that they have fully, effectively represented you up to this point in time.
Yes, Your Honor.
And you're obviously then satisfied with them as your attorneys.
Yes, Your Honor.
Then, as to count 1, aggravated murder in violation of 290301A, an unclassified felony, how do you plead?
Guilty.
Count 2, aggravated murder in violation of 290301A, an unclassified felony, how do you plead?
Guilty.
Count 3, aggravated murder in violation of 290301A, an unclassified felony, how do you plead?
Guilty.
Count 18, felonious assault in violation of 290311A2, how do you plead?
Guilty.
And count 20, felonious assault in violation of 290311A2, how do you plead?
Guilty.
Are you entering each of these pleas of your own free will?
Yes.
No one's forced you to enter these pleas at all, correct?
No.
Fine. And on behalf of the state, the statement of facts?
Judge, may I add?
Yes. Mhm.
Please, court. On or about June 15th, 2023, 1965 Laurel Lindale Road, Claremont County, Ohio. The defendant did purposely and with prior calculation and design cause the death of his 3 children, Clayton Doerman, age 7, Hunter Doerman, age 4, and Chase Doerman, age 3. On that date, Judge, June 15, 2023, the defendant returned home early from work and had his family, including his wife, Laura Doerman, with him. All 3 of the boys joined him in the master bedroom for a nap. At some point after lying down with the 4 of them, the defendant got out of bed, opened a gun safe that was next to the bed, removed a Marlin Model HC-22 rifle from the gun safe and loaded the magazine. The defendant shot his son, Hunter Doerman, twice. While in the bedroom, his wife, Laura, began to render aid to Hunter and yelled for the other children to run. Laura's 14-year-old daughter, Alexis, who had been watching television in the family room, made her way to the master bedroom and witnessed the killing of Hunter. Alexis immediately began to run and indicated that Clayton had fled out the back door, and that Chad Doerman was following Clayton. She ran to help to try to protect Clayton. Anyway, the 3 of them go out the back door. Clayton's first, then there's the defendant, and then Alexis. Alexis witnesses the defendant chase after Clayton, raised his rifle, fired numerous shots at Clayton as he fled, and saw Clayton fall in the field after he was struck by the gunfire. Alexis then watched as the defendant approached Clayton while he's injured, lying on the ground, defenseless, and saw the defendant put a bullet in Clayton's head, killing him. The defendant, Alexis then, Your Honor, ran back, fled into the residence where she picked up the youngest child, the little 3-year-old boy, Chase Doerman. She attempted to flee the residence with Chase to protect him, but the defendant saw her crossing the yard. The defendant gave chase, pointed the rifle directly at Alexis' head, and threatened to shoot Alexis if she did not drop Chase. Alexis put Chase down. He's crying the whole time. The defendant then pointed the firearm at Chase's head, but it just clicked. The magazine was empty. Alexis begged for the defendant not to shoot her. Chase then saw his mother, who had come outside at some point, trying to render aid to Hunter, So Chase runs to his mom. And then there's a very difficult situation that evolved where Laura and the defendant struggled over the weapon. Laura was bitten as she tried to protect Chase from the defendant. The defendant bit her. She put her thumb over the end of the barrel in an effort to stop the bullet. She was shot in the thumb. Ultimately, she had to drop Chase. During this point in time, the defendant was able to reload the firearm and pointed the gun at Chase's head and executed him, one round to his skull. Alexis, Your Honor, suffered serious physical harm as a result, or psychological harm as a result of being held at gunpoint, forced to surrender Chase to the defendant for his execution, and witnessing her stepfather execute her brothers. Laura suffered serious physical harm, obviously, as she was shot through the thumb. Police arrived. There was really nothing that, despite her desperate fighting to save the lives of her boys, there's nothing Laura Doerman could have done. Surrendered without incident.
You're awesome!
Acknowledged immediately, he did it, take me to jail. He later gave statements, Your Honor, that he had been thinking about killing his boys since October, and that these thoughts of having to kill his sons were weighing so heavily on him that he hadn't slept in a few days. And those are the facts, Your Honor. Those are the facts that led to the death of Clayton Doerman, Hunter Doerman, and Chase Doerman, and the permanent, irreversible injuries to the psyche of Alexis and also Laura. Thank you.
Thank you. Mr. Myers, any issues with those facts for the purposes of the plea?
Your Honor, on behalf of Mr. Doerman, we accept and acknowledge that those are the operative facts that the state would rely upon to attempt to carry its burden of proof at trial, and that those facts would have succeeded in carrying the burden of proof at trial had the jury rejected the insanity defense. We're pleading guilty today. We're not trying this court to you, much less to anybody else in this court. I just ask this court to bear in mind the three reports from three different psychologists that are before the court and have been for quite a while, and simply add, not to dispute the sequence of the events, the lethality of the events, the horror and the tragedy of the events, but to add that but for some of the mental health issues that Chad had failed to address, he hopes others will not fail if ever they encounter that again, that but for those mental health issues, it seems fair to say certainly 2 out of the 3, if not all 3 of the psychologists, would acknowledge the odds of this happening would have been near 0. But I also, by adding those facts, further acknowledge we're withdrawing the insanity defense. We understand the dispute between the experts on that. And Chad stands ready to proceed with this hearing and accept responsibility.
Okay. And Mr. Doerman, up to this point in time, once again, have you been able to hear and understand everything I have discussed with you, what your attorneys have stated, what the prosecutors have stated?
Yes, Your Honor.
Do you have any questions, any misunderstandings, any disagreements with anything that's been said this afternoon?
No, Your Honor.
You were able to hear the statement of facts that the prosecutor read regarding the sequence of events as acknowledged by Mr. Myers to be accurate. Do you also believe that those are true?
Do I believe they're true? No.
Okay. You understand that they're accurate? That, as your counselor said, that's accurate?
Yes, Your Honor.
And I need to review the guilty plea form with you at this point in time. And again, the guilty plea form sets out the charges that you're in your pleas to. They have counts 18 and 20, felonious assault as a felony of the second degree, has the statutory provisions, has the possible penalties that are involved for those. 2, has the aggravated murder counts and counts 1 through 3 with the maximum sentence that penalties that are set forth for those 3 charges as well, potential fines, has the dismissal, if you will, of counts 4 through 9, 10 through 17, 19, and 21. And we're waiving any requirement to regarding Reagan Tokes and any post-release control because that's inapplicable and is a vain act. And it also sets forth the agreed, jointly agreed recommended sentence of life without the possibility of parole as to counts 1, 2, and 3. Each of those sentences to be served consecutively with one another. And also the minimum prison term of 8 years on both counts 18 and 20, accumulated to a total minimum prison term of 16 years with a maximum prison term of 20 years, again subsumed, if you will, by the life without parole as to the first 3 counts. Were you able to review this with Mr. Myers and Mr. Haynes before you signed it?
Yes, Your Honor.
Did you understand everything that was written on this document and the consequences of signing it?
Yes, Your Honor.
And did you sign it of your own free will?
Yes, Your Honor.
It has your signature on the back page. It appears to be in blue ink, but you signed this voluntarily after reviewing it with counsel and understanding the full consequences of signing this guilty plea form.
Yes, Your Honor.
Based upon your answers then, Mr. Doerman, I'll find that your pleas have been entered knowingly, intelligently, and voluntarily, that you're guilty of counts 1, 2, and 3, each aggravated murder, unclassified felonies in violation of 290301A, and you're also guilty of felonious assault as alleged in counts 18 and 20, second-degree felonies in violation of 290311A2. And before we proceed with sentencing at this point, I'm going to take a short pause. Everybody can stay in place because the 2 victims, Ms. Laura Doerman and Alexis, want to be here. And at this point in time, all cameras down, all any cell phones, any still photos, anything else in the off position. You're not to record either of these 2 women under any circumstances, and video, audio, and Ms. Barron Allen will read.
Okay, let me pop in here while they're doing this. So what they did was they took the death penalty off the table in order to move this through because there were several delays, you guys. This wasn't even going to go to trial until next year. Excuse me. But it wasn't going to go to trial until next year. Plus, he was claiming, the insanity defense. This was not going to go to trial anytime soon. And it probably would have been super traumatizing for the victims. So what they did was they brought in the stepdaughter and the former wife. They were able to give their statements. And then now we're going to go back to the judge sentencing him now. Oh, and the 16 years is for the assault charges on the mom and the stepdaughter. He got 3 consecutive life sentences for the 3 aggravated murder charges. He's not going anywhere. Any way you slice this case, it is a disaster. It's horrific. Nothing would bring justice for those 3 boys. Really. Those 3 beautiful little boys whose lives were senselessly taken away when he shot them execution style. execution style. What mental condition makes a father do this? Something's going on here for him to plan that. Why? He had a Bible. He was muttering bullshit. Something's going on, you guys. I don't know. It's bizarre. So they went to the break. Da 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 da. I didn't know we'd have to fast forward. Okay, here we go. And this grants them privacy as well. You know, the victims not having to go through this trial, not having to see that body cam, not to have it all over the news again. I mean, there's so much, if you think about it, that they would have to relive and see.
Dr. Dreyer acknowledged it. They don't agree on what. Would never have done that, except that he was delusional. He was in psychosis when this happened. All three psychologists basically acknowledged that. Dr. Dreyer acknowledged it. They don't agree on whether it qualifies as long enough for serious mental illness or whether he had some appreciation of the legal wrongfulness of what he did.
He just said that the doctors said he was in psychosis. He was in psychosis as he planned it. For how long did he plan it? Psychosis. Put a 1 in chat if you buy the psychosis, that he was in a psychosis. A mental health episode made him plan the murders of his own children. Plan it?
When this happened, all three psychologists basically acknowledged that. Dr. Dreyer acknowledged it. They don't agree on whether it qualifies as long enough for serious mental illness or whether he had some appreciation of the legal wrongfulness of what he did. But the fact is, he loved those boys more than anything. And he was ill. He was sick, profoundly sick at the time. There's nothing more he can say at this point except that he's sorry about that. He did it. He acknowledges that. He's taking responsibility for it. He can't bring those boys back and do anything to do it. I think he would wish that he stayed at the little clinic for a little longer than he did. I think he wished that, in hindsight, he put signs there before this happened. Tried to power through it. He wouldn't do that again. And until it was too late, he couldn't. He was out of control.
Anything further on
Sorry for
that?
that. No.
Mr. Doerman, is there anything you want to say on your own behalf before I impose sentence?
What a pussy.
No?
Wow. He didn't even have anything to say. He is 150% a P-U-F-F-Y. Let me tell you. He's got nothing to say. I wonder if he was always abusive. I wonder if they had domestic violence issues. I don't know much about their past.
Well, there's nothing that I can add to
If he wanted to punish the mother,
Alexis.
then that just shows he's one of those man babies that can't handle anything. He can't handle rejection. He can't handle relationships not going well. He's a big coward. Exactly, Melanator. Carol, I agree. Gary Davis, they said that he was not on drugs. They said he was not on drugs. They said he was having a psychosis episode. Yeah, the neighbors said there was prior domestics. Kelsey says Chad is a cooter. He is. All right, let's listen to the judge sentence this coward.
And Laura Doerman. Those were two of the most compelling statements I've ever heard. With that said, Mr. Doerman, as to count one, I'll impose a prison sentence of life in prison without the possibility of parole. No fine will be imposed. As to count two, it'll be a life prison term without the chance of parole. And count three, it'll be life in prison without the possibility of parole. These three counts and these three sentences will be served consecutively with one another. As to count 18, it'll be an 8-year minimum sentence. As to count 20, it'll be an 8-year minimum sentence. They will be served consecutively with one another for a total of 16 years as a minimum sentence. The maximum the sentences in counts 1, 2, and 3. All aggravated circumstances have already been dismissed. The firearm specifications will be dismissed. You will forfeit the firearm that was used in this case. It will be forfeited to the sheriff's office for destruction, and it must be destroyed. Appeal for this sentence, so you will serve the rest of your life in prison. I will order judgment for court costs. You have been held in the county jail since June 15th, so there's 415 days that you've served in jail up to this point in time. That will be credited towards the life without parole. There's no restitution and no fines will be imposed. Anything further on behalf of the state, Mr. Colby?
No, Your Honor.
Mr. Myers, Mr. Haynes, anything further?
No, thank you, Your Honor.
Covered everything satisfactorily?
I believe so.
Yes, Your Honor.
Thank you. All right, thank you.
Thank you.
He'll be committed to the sheriff. Bond obviously will be revoked, subject, well, there was no bond anyway, but be committed to the county.
Look at him. He's a crazy motherfucker. Look at his eyes, y'all. Yeah, there's something definitely wrong with that dude. And you know what? It's a blessing that he will no longer be in society. Do you get endless appeals in Ohio? Seems to be like that everywhere. I mean, really. Except Florida. Florida actually uses the death penalty. Let's recap, though, what we just heard and saw. So here is a brief little background and update. So after more than a year of court developments, and imagine, being the victims in this case going through over a year. I mean, think about Idaho 4 with Brian Koberger. It's hell. The Gonsalveses have said it is absolute hell. They just want the trial over. So I think that this is good for, the victims in this case. But it says after more than a year of court developments, including a ruling that barred his alleged confession from trial. So his confession was ruled out. They weren't going to use the confession. The man accused of gunning down his 3 young sons on June 15th, 2023, pleaded guilty on Friday. He was charged with 9 counts of aggravated murder, 8 counts of kidnapping, and 4 counts of felonious assault. Instead, he pled guilty to 3 counts of aggravated murder, 1 charge for each of 4-year-old Hunter, 7-year-old Clayton, and 3-year-old Chase, and 2 counts of felonious assault. Judge Richard Farrick said as a result of the plea deal, Doerman is no longer eligible for the death penalty. Farrick said Doerman would be sentenced to life without the possibility of parole instead. And that sentence was just handed down. We just watched. Both Doerman's ex-wife and stepdaughter prepared statements that were read aloud by one of the prosecution's attorneys. His stepdaughter's statement said that while she could never forgive him, she said she couldn't hate him because of the dad he was to her before he killed the boys. Wow. Wow. I have to say, I'm shocked. Let me read that again. His stepdaughter's statement said that while she could never forgive him, she couldn't hate him because of the dad that he was to her before he killed the boys. And that was his stepdaughter. I mean, for her to even be able to say that, wow. His ex-wife's statement talked about the emptiness and silence that Chad created by killing the boys. Can you imagine how quiet her house is? You have 3 rambunctious boys, 7, 4, and 3, and all of a sudden your house is just quiet. It's got to be like a silence that just like deafens the ears. You know what I'm saying? She said she talked about the emptiness and silence that Chad created by killing the boys. She said she grieves them every day and misses the little ways that they would say, I love you. Chad Doerman was initially scheduled to appear in court on the 5th, yes, of this month in 3 days. But that hearing was postponed, and instead he appeared today for a last-minute hearing, which attorneys said surrounded a plea. The case has been proven to be a roller coaster with many twists and turns over the past year. Oh, absolutely chilling. Gosh. Heavy. It's heavy. But you know what? We don't ever have to see him again. He's gone away forever. No chance of parole. No parole hearings. No bullshit. But anyways, guys, I have got to wrap this up. So this is going to conclude our Friday Live. I know it's short today, but we've got a tropical storm watch going on right now. So like I said, we've got to get things hunkered down, get ready just in case it does come our way. Melanator says, stepdaughter is a strong and young woman. God bless her and protect her from here on in her life. And I agree. I agree. But what a kind heart she has to be able to say that. I feel like she probably is getting extensive therapy. For her to even be able to say that, like, I don't forgive you, motherfucker. I don't forgive you, but I don't hate you, because you know what? She's a smart girl. She's a smart girl, because you know what hate does? It eats away at us. It eats away at us. All hate would do is hurt her heart even more than he's already hurt it. She's very smart. That's very healthy. And I think, wow, what an amazing young woman. What an amazing young woman. Let's see where we stand. Wow, you guys were about almost 50-50 on the poll. It is a very mature outlook. But you know what? You go through something like this and you mature real fast. You mature real fast because you don't have a choice. When a child, especially a teenager, is met with life or death in their face, they instantly grow up. My son has that same insight because he narrowly escaped death, but witnessed someone else die at the same time. And he has this wisdom about him, and he has this maturity about him, but he's still only 25. You know, he's still immature in so many ways, but he's got so much wisdom and so much outlook on life that he's one that tells me spend time, you know, spend time. All right, you guys, I love you. Spend time with those you love. That's what I'm going to go do right now. You guys are the greatest. I love you all. I appreciate you. Thank you for your support. And we will be live probably on Sunday. I'll keep you posted, though. Make sure you check out the community. And if I can, if it's a storm, I'll go live, whatever. We'll see what happens. I love you, Myron. Let's roll our credits. Thank you so much for watching. If you enjoyed this live stream or video, make sure to give it a thumbs up and hit that subscribe button so you don't miss out on my latest content. Want to take it a step further? Bring it all in. And join our community clickers by becoming a Patreon or a YouTube member. You'll get exclusive access to our Discord server, special channel perks, and much more. Until then, I'll see you in the next one.
Click, 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 click. It's real easy, man.
I don't give a damn. I don't really care about you and your problems. I don't give a damn. You talk way too much. I have heard enough about you and your problems. I don't give a damn. I don't give a damn. I don't give a damn.
Man, go to that dang old internet, man. Click, 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 click. It's real easy, man.
I don't give a damn. You wanna be, you wanna be, you wanna be with me. You wanna feel something real, but I'm feeling differently. You're making plans to get to friends, but don't wanna face the fact that I ain't got time, I ain't got time, I ain't got time for that. Staying up late, sleeping all day, dreaming about Cadillacs. Buying new shoes, hanging by the pool, sipping on Coke and Jack. Calling my phone when you feel alone, but I never call you back.
Thanks so much, Jennifer.
Jennifer loves horses. Bye, Jennifer.